The Supreme Court handed down a ruling last week in a pair of cases dealing with public officials blocking users on social media. According to the ruling, public officials cannot block users if they use the account for official announcements. What's your take?
I think this is actually, surprisingly, a pretty good ruling from the Supreme Court. And you know, like you said, you had these two separate cases, and it involved small-time local officials.
Yeah.
One out in California, one up in Michigan, and they just kind of combined the cases.
Right.
But these officials were getting real mad with their own constituents, you know, calling them out on Facebook and Twitter. So they just said, well, I'm going to block you. Even though what I'm doing is I'm using my account for official business, doing the proclamations, putting out important community information, I'm blocking you because you're just annoying me at this point. And so the constituents filed suit. They said, well, listen, I know, yes, I'm pissing you off, but I have to have access to this information. You're violating my constitutional rights. And the court overwhelmingly said, yeah, I mean, you can't do that.
It was a clear, I mean, look, why would it even get to the Supreme Court, right? I mean, why would it even get there? It's a clear First Amendment issue. It's the idea of a politician being able to say, you know, there's some things you can't say to me. A, I didn't do my job right. B, something I'm doing is irregular, maybe illegal. You can't do that. It's a new policy in America. That's where this was going, because they were using this all over the country.
Yeah.
In little, everything from, as you point out, city commissioners, county commissioners, councils.
School boards.
School boards. Well, we don't like the fact that you called us idiots for some stupid move we make. So rather than fixing the problem, you're just going to go away, right?
Right. And what's so funny about this to me is that here in the state of Florida, we're kind of trying to go the opposite way.
Yeah.
We're trying to go the path where if you call a politician in this state an idiot, they can now sue you for defamation. So they're, you know, doing the absolute opposite on free speech here in Florida versus the Supreme Court. And what's great about this too is I love this, is that you actually had, you know, legal scholars on the left and on the right
saying how bad
that both said, this is a good decision. Thank you
saying
for
how bad the idea is of blocking out constituents.
Right. And, you know, the ACLU said this is great and this is what we need to have. And I will say the court made a distinction. They said, listen, obviously, if you're a public official, you haven't always been a public official. So if you have your private Facebook or your private Twitter and you're using that just as a regular user, sure, block everybody you want. That's your right. But if you're using it either as your official account or you create an official account, you have to leave it open for everybody. And if you don't want to, you know, have these people getting mad at you, maybe be a better politician.
You know, in Florida, and it's not just Florida that's trying to turn New York Times v. Sullivan on its head. That's what they're trying to do. I mean, the law is very clear. If you're a public official, you have stepped into a position where people can be extremely critical of you. It has to be malicious intent. That's how bad it has to be. Something even more than that sometimes. So, I mean, they're never going to change that. But the effort, it's not just Florida doing it. I mean, other states are looking at, well, you know, I'm a public official and you shouldn't talk bad to me. Truth is, it's not going to go anywhere. But again, it's going to be another Supreme Court issue. It's going to go all the way to the Supreme Court when it shouldn't.
Right. We have very important issues that the court does have to decide. Not that I have faith in anyone on that court. But this is just a waste of time.
Yeah,
this should not. This is a Judge Judy case, really. That's what it is.
Okay.
That it had helped dirty money flow through its branches around the world, including at least 800...
Plaintiffs allege that the defendants provided money and medical goods to terrorist groups Hezbollah and Jaish al-Mahdi.
This is a well-organized business for these individuals that carry out these attacks. Terrorism is a business, and they run it like a business.
They knew about what was going on for a decade. They absolutely, no question about it, knew that HSBC was washing money. They had every reason to understand it was for terrorism and it was for drug cartels. Took no action whatsoever.
these banks are involved. Their accounts are connected, and they're using them to mask the transactions. The more complicated they can make the transactions, the more distance they can put between the bad guys and a seemingly legitimate purpose of these funds.
They pay $1.9 billion, which is a drop in the bucket compared to what they've made, and nobody goes to prison. These CEOs, these bankers that made this decision, they're safe at home. They know what they've done. It's resulted in the death of Americans, contractors and soldiers, not just hundreds, but thousands. And we look the other way because they don't look like criminals. The die is cast. The people that are responsible are on Wall Street.
And they don't look like criminals. It's almost a suspension of disbelief. Sometimes I'll have people call me and say, is this real? Do they really get away with this? Yeah, they do.